Good evening, everyone. I am Rashmita from ESL, and I hope everybody is doing well. So, I'd like to welcome everyone to the wonderful session that we are going to have right now with our guest, Mr. Arindam. So, here is a little brief about him. Mr. is a patent attorney at Khurana Khurana. He is a registered patent agent, INP 1344 with bachelor degree in applied science from Delhi University, law degree from Delhi University, and MBA from IIM Lucknow. He has over 11 years of experience in handling diverse intellectual property matters. He has worked with law firms, pharma, life science companies, IT and engineering companies. He has expertise in national and international IP management, licensing, and IP management. So, if you are also somebody who wants to inaugurate something and wants to get it patented, but you don't know how, so this is a session which is for you. Over to you, sir.
Yeah, thank you, Rashmita. My name is Arindam. The way I want to have this session is that I would expect you to ask me questions at any point of time. In fact, if you have a question right now, we can start that way also. Otherwise, what I want to have is share a couple of understandings and experiences that I picked up over the course of years. Essentially, I'm a patent attorney, but I have worked on certain licensing projects. So I'm familiar with how a startup, tries to commercialize or license their technologies, and also I've done an MBA. So I'll try to combine that and share a couple of things. I'm not saying that I'm a high level of expert in any of these things, but yes, I can definitely share a couple of things which I believe could be useful for you as you move through your career or if you start your own venture and all. So with that in mind, bear in mind my rule. You should be asking questions. I am not going to have a monologue here. I'm just starting the proceeding here. So I'm just sharing my screen here. Give me a second.
Yeah, guys, and since it would be a two-way process and most of the discussions would be from both end, so I would request maximum participants to switch on their camera because it will make more.
Yeah, let's keep it chill and casual. You ask any question. If you think that your question is very silly or doesn't make sense or doesn't go with the sync of flow of that discussion, but still, please ask. Huh? Don't shy away from asking questions. Who knows? Maybe your question would be relevant if you can discuss things from, or if you come out with something else from that. Uh, so before I start, actually, just recently I came across this particular notification. I want to actually proceed in this particular manner instead of sharing expanding the whole thing and creating a slideshow out of it, because I can then maneuver through the slides and all. I hope you can see this. I can maybe expand the page a little bit. So just recently, government introduced this Northeast Accelerator. So you can check it over internet also. But I think it might be useful for you guys because most of you are also from Agartala, at least starting your education there. So maybe you can set up your own small venture or SME there also. So this is something that has been started by Japan International Cooperation Agency and IIM Calcutta. So they are focusing on this Northeast Accelerator. So just check this out. I think you can find something relevant for you. I just saw this 2 3 days back, so I thought I'll just introduce before I get onto the settings. So agenda, I would say we do not have any agenda. At one side, I want to discuss about intellectual property in general, focus a little bit on patent part because from a technology point of view, patent is a little bit more important, but it doesn't mean that other aspects of intellectual property are not so important. And along with that, I will talk about managing innovation, a little bit about entrepreneurship from IP perspective, because that's what I know about a little bit. So to begin with, what I want to tell you is that, for example, patent. Okay, it's not that you are not aware of this word and you're not hearing it for the first time. But when you think about patent, what you think is that okay, I have something. Let's think about patenting it. I just want to expand that thinking a little bit because when you think of only patenting it, say for example, only patenting, then in a way you are just looking at this colored light of the entire spectrum, wavelength, electromagnetic spectrum. Basically, you are missing out on the ultra high or ultra low wavelength and all. So when we talk about intellectual property and managing it and all, we are actually looking at a lot of different wavelengths which go on either extent, either side of the visible light. That is how I want to show you. So IP filing or patent filing and then prosecuting it and getting a grant is just the visible spectrum, visible light. But there are other ends to it. So even if you're thinking of patenting something, there are a lot of work that you can do, research work to find out who else are doing some kind of technology work, whether there's an open space, usually we call them white space. If there's a lot of activity going on, and at least in fields like telecom, high-tech technology, it's pretty common. So those spaces become red in a way. So we call them red spaces or black spaces. So a lot of research work can also be done based on patent databases. Similarly, on the other end of the spectrum, once you have the patent, then what do you do with it? It's not just for show, right? So you need to use it, you need to commercialize it, you need to manage it, you need to enforce it. If somebody is misusing it, so you need to take action. If you have it and you're just not using it and just lying there idle for 10 years or 15 years, then that also is not serving purpose. So you need to think of ways to commercialize and exploit that patent or intellectual property. Because ultimately, intellectual property is giving you some kind of exclusivity on that intellectual property. Other thing to remember here would be that intellectual property, the second word, the property, is also very important. When we use the word property, it signifies that ultimately you're dealing with an asset. So just like any other asset, say for example a land, a building, or even an automobile or your laptop or mobile, you have to treat this intellectual property, whether it's a patent, trademark, design, copyright, you have to give it the same kind of respect and you have to maneuver it the same way that you would do with any other property. Hey, even if you're buying a vehicle or a laptop, you do your own research work, right? You check out whether these things make sense to you for you to buy, whether it fits the right pricing, and then what kind of model you want, what would be suitable for you, whether you want a gaming kind of laptop or basically utility kind of laptop. Property, if you are buying, then whether you will see whether it's a corner property or say, facing which side of direction and all this kind of stuff. So same way it goes with intellectual property also. Say for example, forget about patent and all, let's suppose you want to start a business, so you want to launch a product and you want to think about a trade name XYZ, say for example. Now you cannot just go and start using that trade name XYZ, because then there's a chance that somebody else might also be using it already, you may not be aware of that. So you need to set those things right, and because of that you need to do your search, little bit due diligence. So those kind of things also become important. So when we talk about intellectual property and managing it, basically always remember that we are talking about managing an asset. So it's an intellectual asset management basically that we talk about. So that would be the overall game plan. And now, before I begin, I would like to know whether you have any questions. We can then discuss on those particular aspects, and then we can discuss anything that is there with me. I will not proceed if you don't have any questions, because I am really expecting to have questions. Let me stop sharing my screen so that we can get back to you, and hopefully I'll get some question from you. Any question? What is intellectual property? What is patent? Different kinds of intellectual property. Any question?
Yes, sir. I have a very silly question.
No, no, no. There are no silly questions. Because see, idea here is that, see, you are students right now. Okay, after 1, 2, 3, 4 years, you will either work in some company. Okay, and these days, what has happened is, companies' expectations have also changed. It's not that you just go there and start doing work. They expect you to think little bit laterally and in different aspect. And frankly speaking, I've worked with companies. They most of the people there may not be so familiar with intellectual property and how to use it. So it completely makes sense that you take that edge with you. So please ask questions. No problem.
Yes, sir. So my question is, sir, how do we identify something as our intellectual property, like that we should think for patenting or something?
Yes. So for that, you need to look at that entire intellectual property, what I call as solar system. Okay. So then let me go back to my slide and show you what I mean by that. And then I would expect some more questions from you, right? This is how I would like to proceed, because this is the best way to actually for you to absorb the things. Okay. So if you look at this, when we talk about intellectual property, these are the on the left side what you see. These are the 7 typical intellectual property. They are defined by law. In general, what we mean by intellectual property is something that has been created by intellect, your mind basically. So if you see copyright, there are different kinds of copyright. A simplest form would be if you write a story, comic book, or a poem, anything like that, that can have a copyright. But the point here is those things have also been created by the mind. It's not that you have physically created chair, table, or something like that, or it's something or it exists. For example, land. So it's not like that. It's something that has been purely created by the mind, and the government in general has recognized that this should be protected because some effort has gone into creating that, and ultimately all these things add to the knowledge or the utility of the society in general. So uh, I call it planetary system because there are at least 7 of them. Maybe you can think of patent as the central one, but doesn't matter. We can say that we do not have a central star or stellar object here, but these are the planets. I'll talk about them, but frankly speaking, the most important ones generally are some that you have already heard of: copyright, trademark, design. I will talk a little bit about the other ones that you may not be familiar with. So the other one would be like geographical indication. So if you hear things like Darjeeling tea or Kolhapuri chappal, so these are geographical indication. These protections are given to a particular geography. So all tea growers in the area what is defined as Darjeeling, they can use this indication to say that our tea is Darjeeling tea. So if somebody is growing a tea in Assam, they would call it Assam tea. Assam tea is a different geographical indication. Same with Nilgiri teas. Nilgiri is an area different from Darjeeling and Assam, so they have a different geographical indication. Now, sometime back, I went to Nainital and I saw the tea garden there. So they would just call it tea leaves. They do not have a geographical indication per se. Nainital tea growers. So they cannot call it Darjeeling tea. But yes, Darjeeling tea growers, they can call it geographical indication. And there are at least, I think, close to 100 geographical indications, at least in India also. So in wine, if you hear the word champagne, champagne is also a territory in France. So any wine that is produced in that particular region, village or town or city, whatever it may be, known as champagne. So any wine produced there can qualify and can call itself to be a champagne, but none others. Plant variety and breeder right is something that is new, but again pretty important these days, at least from agricultural point of view. You may have seen a lot of growers coming up, so a lot of varieties of mangoes are coming up. Same with a lot of vegetables and all. So if they are creating their own breeds through natural processes, inbreeding and all, so those kind of things are also protected under plant varieties. These days, a lot of commercial entities are taking advantage of this. You may have heard in news, PepsiCo, they are protecting their breeds of potatoes, and they are not allowing other farmers to use their protected plant variety protected breeds of potatoes and all. Layout of integrated circuit is also an area covered under intellectual property, but nobody knows about this. The integrated circuit, it has a peculiar layout. Those layouts are also unique and they can be also protected. Patent is of course something that you're familiar with. I'll then come to the other three, basically design. Design basically means anything that you see physically, and the protection is given to the visual part, what you see and what you feel from the aesthetic looks of it. So if you see a car, a vehicle, the outer appearance is protected by design. Even its headlamp can be protected under a separate design application. Its tire rim can be protected under a separate design application. Mirrors and all, they can be protected under separate design applications. So that is how they are. So almost anything can be protected under design, but just remember that usually the shape and the way it looks are protected. So it can be for a bottle or lamp, anything like that. But that's how designs are. They protect the appearance basically. Trademark, I think you would be familiar with. Anything you see, for example, Unilever, Cadbury, these are all trademark. Coca-Cola, these are all trademarks. Uh, Something that you should know is that these days a lot of unfamiliar trademarks are coming up. So if you see Cadbury, okay, now when you think about Cadbury, you also know that it has this unique purple color. So what has happened these days is that if this color is associated with Cadbury or at least with chocolate, then Cadbury has taken protection on those colors also as a way. So trademark can be given on certain unique things which may not be purely the name and all, but certain other aspects also. For example, Yahoo has a trademark on the UDL that they have, Yahoo. So they have a trademark on that also. And copyright, as I mentioned, covers anything that is written, basically. So it can be a poem, it can be an artistic work, even movies, cinematograph. Those things are also protected under copyright. But the important thing for you as student would be software. So when you write codes and all, those are also protected under copyright. So I believe you might be familiar. A lot of codes are also available on open source. So they understand that they have a copyright, but the authors of those copyright have allowed to give them out for certain rights or restrictions. So the point for you as student is to remember that you have copyright on software also. So when you write a code, you can get a intellectual property protection of the form of copyright. Now to come back to the question, how do you identify? You need to understand the different types of intellectual property first, and then see what you are doing. Say for example, if you are starting a business, now the first thing you might do is create a name for your company. When you do that, obviously first thing you might do then would be start a company, name registration and all, company formation and all. And then the first step that you actually would be taking from intellectual point of view would be filing for a trademark protection. So either you secure a trademark on that company name or a particular brand name. Say for example, if you launch a particular device, a mobile phone, under the company name ABC, you have a mobile phone, say XYZ. So Apple may have mobile phone named iPhone. So Apple could be a different trademark, and then iPhone would be a different trademark. So same goes for anything else also. Any kind of product that you launch, any product basically that can be associated with you, that you are the creator of this, those things can be protected under trademark. And if you're creating some kind of software, if you're writing something, you have created a user interface, an app or something like that, where the visual part is there for all to see. Usually, if you're creating an app, then there are certain design work that has gone in, artistic work that has gone in. So those things you need to, just keep your mind, track your mind up and forward, basically, that you can then protect them under copyright. So there's no hard and fast rule about it, but the point is you need to be familiar with these intellectual property for you to utilize them. Because you're familiar with patent, because you're from technology background. So this is a field of intellectual property that is very familiar to you and you can associate with it. But the point is there are other intellectual property that can be easily applicable to you or whatever business that you do. Generally speaking, the most applicable ones are copyright, trademark, and design. So if you're creating a product, if you have a 3D shape, 2D shape on those products, definitely seek design protection. If you have a logo, name, or anything that you want to be associated with your goods or services, secure a trademark. And if you're writing something, if you're creating an artistic work, if you're writing a song or anything like that, then software, then take a copyright protection. Last and least is trade secret. Whatever you don't want to reveal to others should be protected as your trade secret. Generally, these are all protected, by secrecy, confidential agreement, and all this kind of stuff. Because understand this, patent also has a limitation. When you secure a patent, what you do is actually you reveal your invention to others. So in return for your revealing this invention, you get a 20-year exclusivity, and nobody else would be using your innovation. But let's suppose if you don't want to disclose, then you can keep it as a trade secret. For example, a good example here would be Coca-Cola. Most people think, and I also may agree with that, that their formulation is actually a trade secret. They have kept it sealed and a secret basically for the last 100 or so years. If they wanted, they could have taken a patent of that formulation, how to create that drink and all. But they prefer not to do that, and they usually prefer to go the trade secret route. From a recent example, what I have learned basically is Elon Musk is also in favor of going for trade secret rather than filing patent. So that's why he's not bothered about Chinese manufacturers infringing their patent or subverting their technology, because they say that everything for us is protected by a trade secret. So this is the long and short answer of your question. Any follow-up question on this though? I'm expecting some follow-up questions here.
So, good evening, sir. Sir, for example, sir, there was a recent news that Sony wasn't able to release PS5 in India because some guy patented the name for himself. So, is a patent that's filed in India be valid in USA and other countries or not?
Yes. So patent, or for that matter, any other intellectual property other than copyright. Okay. So they have a territorial specificity. So because understand this, patent or trademark is given by the government concerned. So they can only give you that protection for that particular territory. So any company, if they have filed a patent in a particular territory, say for example you, okay, you if you have filed a patent in India, because of that patent and because of the assurance given by the government of India, you would be able to enforce that patent in India. Nobody would be able to use that patent or that particular trademark in India. But let's suppose if you have not filed that patent in US, then what has happened then is that your patent has become open for others to use in US. So in that case, anybody else, including you, can go to the US market and sell the same technology, and there won't be any exclusivity associated with patent that you will enjoy there. In this case, also, I'm not familiar with this news. I am familiar with another news that happened some time back with Toyota. They were trying to launch their branded vehicle, Primus or Prima. What is the name of the vehicle? Okay, doesn't matter. So once they tried to launch, they realized that some Indian automobile dealer, they are a small vendor basically, and they had trademarked this particular name. So Toyota tried to fight for Toyota fought hard, but at the end of the day, they did not get the trademark on that Primus or whatever be the name of that automobile segment. So yes, those kind of things can happen. So that is why again, managing your intellectual property is also important. This is something that you may use once you start your career. Once you join a company, you may start to think about these particular lines. Or if you're starting your own venture, these are the things that you need to think about. Let's suppose if you have thought of some idea. Let's say you have thought of three things. You have thought of a product. Now this product includes a patent, so you have to patent it. It it would ultimately also use a name, a unique kind of name, so you have to trademark it. And because this is a product, it has a shape and appearance. You may think about design protecting all that also. Now for all these three, you need to ensure where all do you need to protect it. For example, obviously your obvious choice would be India because you are residing in India, and obviously you look at India as a market potential. But the thing is, you also need to keep in mind whether you want to protect it in US or other countries, because for at least for patent, if you don't file that same patent within a year, you cannot take a patent application later on. At least in trademark, what you can do is you can go to US after 5 years and secure a trademark protection, but that won't be possible in patent, in the case of patent. So in your Sony example also, this what might have happened is that these guy might have taken the name. Usually these things are called trolls. In intellectual property also, these things exist. People just sit on them basically. This trade name. It's also very common with domain name. Domain name is also a part of trademark only. A lot of cases happened earlier, but now the law on domain name is settled. It's treated as a trademark, and anybody who's just sitting on a trademark can take action. The same thing here. What these guys might have done is obviously they know that someday PlayStation would launch 6 or 7 or 10 version. So just anticipating that, they may have taken a trademark on that. They may not be using it, but they still got the trademark on that. Now it's not the end of the road for Sony. Also, they can take action, but they have some limited remedies available with them. If, say, for example, these guys are not using the trade name at all, so one ground that they can take is that these guys, Indian fellows, they are not using the trade name at all. Usually, government gives you 5 years time to start using the trade name. If you're not using, then it becomes open for challenge and all. So that is one route available. But the short and crisp answer to this is that intellectual property are generally territory specific. So whenever you're thinking about filing or taking a patent or a trademark, you should also keep your international perspective in mind, whether you need to or you want to seek a protection in those particular countries or not. So they need to go hand in hand. So just because you filed a patent in India doesn't mean that you have achieved everything about that. If you think your market exists for US, you need to think about it and secure a trademark or a patent in US also.
Sir,
Yes,
adding
sir.
to
Thank
that
you, sir.
question,
Yeah, please.
yeah, sir, adding to that question, like there are different patent authorities for different countries. So,
Mhm.
is there any central body where we can just file a patent and it will administer patent registration in each and every countries, or we have to individually do go to every office or like file online but patent?
Yes. So currently, short, basically how it stands is that you need to go to each country. So there is an international system. Generally, this is called a PCT system, but that is still, a facilitating mechanism. uh, it will allow you to file an international application, and then it gives you an extended time period by which you can, for example, I mentioned that you need to file it within 12 months. So it extends the time by another 18 months, and but the point is you still will need to go to each country. So there is not a centralized international mechanism by which you can, file one particular patent and then you can secure rights all over the world. It's the same for all companies. Say, for example, Samsung. Actually, if I go back, say, 10 to 15 years back, you might recall that there were a lot of, Chinese companies selling mobile phones in India. I would not even know their names, or even if they were there, they have stopped doing business in India right now. So the reason why that happened was that, most of these technologies are owned by companies like Samsung, Ericsson, Apple, and these major telecommunication companies. So at that point of time, say late 1990s or early 2000s, when they came up with these technologies, they may not have chosen India as a country where they want to, protect these patents. So these Chinese companies exploited that gap, and they manufactured these handset based on those technologies, say in China, and then they sold it in India because in India those technologies were not protected. That's why such phones existed in India at that particular point of time. But these phones were never sold in US. Price was not the issue, but the technology availability was an issue. That this technology was available for free use in India, but was not available in US. Had they gone to US, any other technology owner, Apple, Ericsson, they might have sued them. But now, obviously, you may have seen that the trend has changed. So that is because companies realize that they need to secure their patents in India also. So now, most of these large companies, they invariably file a patent application in India, even if they have no plan to use it. They still file it because they know India is an important market for them.
Okay, sir.
Yeah. So the point is that if you're thinking of filing, first file it in India. Of course, that is your choice. But then at least start thinking whether you want to take them outside India or not. So that is one aspect that you need to keep in mind.
Good evening, sir.
Yeah, please.
Sir, I would like to know how long does it take to have a patent in India? Like, is the process longer in India in comparison to other countries?
Yes. So if you look at a normal process and a normal route, then it takes some time in India. Sometime back, I would say almost 10 years back, it used to take almost 6 to 7 years to get a patent in India. Nowadays, the time has compressed because earlier the problem was that they did not have sufficient staff at intellectual patent office or intellectual property office, to examine those applications and dispose them. Now at least things have improved, but still, at least in India, in a normal process and all, it can still take around 2.5 to 3 years to get a patent. There are certain routes and certain options available. Say, for example, if you file it as a startup, if you pay an expedited examination fee, or just last year a new scheme was introduced by the government of India. So if the lead inventor is a female, then you can expedite the process, and then in that case, it's possible to get a grant within a year also. So in some of our cases, we have managed to secure patent grant within 8 months also. But I would say typically, if you expedite and if you fall under that bucket, you can get a grant within 1 year. But if you are following a normal process and all, then expect to take at least 3 to 4 years for your patent to get granted. Along with that, and this is the reason why I ask you, why I request you to ask question, is that I can then tell you a little bit more on that particular subject. Another thing to note here is that you don't need to actually have a patent registered or granted to start using your inventions. This is a bit of a misconception that you need to have a prototype ready, or you need to have everything model, everything ready for you to start filing the patent, or in fact you can start using the patent after your grant. So the two things to note here is that you patent filing activity is independent of your development activities. You can file the patent whenever you feel that you are mentally ready to file it. As long as the concept is ready in your mind and you can translate that into a paper form, you should be filing it. And it has nothing to do whether you can translate that paper form into a model or a prototype form. And you don't need to wait till your grant also. Basically, you can start either using it or not using it as per your convenience whenever you want. Another point that I can add here is that try to file your patent application before you start publishing a paper or any kind of marketing. Because see, one of the criteria of patent is that it needs to be new, and novelty is decided based on worldwide level. So if you file a patent and if somebody has filed say 2 days before you a patent application in China, so then that destroys the novelty. So try to file the patent as soon as possible, and then you publish your research work, marketing material. If you want to take it based on that, you do that, so that at least your novelty remains intact. So this is just a precaution that you can take. This is covered in one of my slides, but since you brought up this topic, thank you for bringing this topic up. So I thought, I'll just share this. Otherwise, it can get lost in
Sir,
the. Yeah, please.
yes, sir, I have a question. Let's say if someone has a patent in India but not in USA, if there is a same
Mhm.
product in USA, so can
Mhm.
the person in USA expand his business in India as there is already a patent
No. So that is what you get with
one patent?
patent. In India, you have an exclusivity. Okay. Nobody would be able to sell, export, import that particular product in India, assuming you have a valid and existing patent in India. Okay. But rest of the world, US, China, and all, they remain open. Basically, anybody can come and into that market and exploit that market. So that is how it is. But yes, if you have a patent in India, then nobody would be able to do anything in India. They cannot bring it from other countries and sell it in India. They cannot manufacture it here in India for sale outside India. They cannot do. Whatever they want to do, they need to take a license from you. They need to take a permission from you. But yes, if you don't have a patent in US, then it's an open territory for everybody. You can also go there. You can sell your product, but you do not get any special exclusivity that patent grants you. It would be open for all.
Hello, sir. I have
Yeah.
a question.
Yeah,
Sir,
I
is the concept?
sorry, Deepnali, to stop you in between. Sir, would you like to add some more slides and then move to the questions again? And
Okay, let's do that. Yeah, but whoever was asking that question, just put a pin on that question. We'll definitely come back on that, right?
yeah,
Yeah. This particular slide, I think I have covered. So definition wise, it's a negative right. So what it means is like, say if you have a mobile phone, you have a positive right because that is a physical property that you have and everything. Patent is a negative right because it, actually speaking, is not giving you anything. What it is giving you is that others will not be able to use that same technology or same trademark in that particular territory. So in a way, you as a person are not getting anything positive. Only thing you are getting is that others, for others it becomes negative. So that's why it's considered a negative right, and it's granted by the government, and it's granted by the government in a quid quid pro quo format basically. So you disclose the invention, and in return, government gives you this 20-year exclusivity. And we talked about this territorial aspect sufficient detail, so no need to talk about that. Patent requirements. So these top three are the basic fundamentals of patent. If you want to file a patent, these three criteria has to be met under any condition. It needs to be having some kind of industrial applicability. This is actually the most easiest hurdle to cross. I think any invention has some industrial applicability, and it is showing or meeting this criteria is not an issue. The issue comes with the other two, novelty and inventive step. Novelty I touched upon. It needs to be new, and as I mentioned, it needs to be new to the whole world. So if you have an invention, you want to file a patent in that, but let's suppose just 1 month before you were filing or you want to file it, somebody in China has just published a paper on that, not even filed a patent, and that publication is in Chinese language. So because of that, and if it discloses the same invention, you technically speaking, because of this novelty criteria, you will not get a patent. So just bear this in mind, and always ensure that at least your invention is new to the extent possible. Generally, as I mentioned, we look at it from a managing an asset point of view. So that's why we do a couple of searches. There are different kind of searches. One of the searches we do is novelty searches, where we try to identify where your invention is new or not, so that accordingly you can take your step. Because ultimately, see, as I mentioned, patent it takes time. You need to put in a lot of money also. So before you spend so much of time, resources, everything, it makes sense to do your search and find out whether you are in the right footing or not. The third one, inventive step, which is called obviousness, this is the most trickiest one, and there is no simple way to explain it. I can give you a couple of examples. Sometime back, I used to see some emergency lights where they would have a switch with a light, tube light basically, and also a fan. So basically, obviousness, what it means is that if your invention is obvious based on whatever is already known to the world, so then it is obvious. So way to switch on or have a tube light is known. A way to have a fan is also known. What you have done is just combine the two and put it in a simple device. So that way speaking, what you've done is combined a light and a fan. So those things are not uh, patentable. At least they are not granted patent. So obviousness, mathematically speaking, what it means is that if one is a known thing to the world and two is also a known thing to the world, then you cannot combine 1 plus 2 get 3. You need to get something more than maybe 3. If you can get 3.1, so that is also fine. But yeah, just getting 3 will not cut the ice. You need to show that you have crossed a hurdle, an inventive step has been made, which was not known to the scientific or the technical community at that particular point of time. So to give you an example from a slightly different field, I have worked with pharmaceutical companies also. We used to develop, vaccines with number of valencies. Say, for example, if you are developing a pneumococcal vaccine, now there are different strains of pneumonia, bacteria and all, like you see these days with the coronavirus also. So there would be, pentavalent vaccine or 10-valent vaccine and something like that. So let's suppose if somebody has developed a vaccine for a particular strain A and somebody else has developed a strain for B, vaccine for B. Now, in the scientific community of vaccine manufacturing and all, it's not always easy that you can just mix the two, vaccine solution of A and vaccine solution of B, because within that vaccine composition, there are different ingredients and there could be reaction or some kind of miscalculation between these two reagents also that comprise the different vaccines. So that is where the scientific community comes in and they replace or they think about a way by which these two can be combined, the vaccine A and vaccine B. So because of all that, it's possible to maybe file a two-valent vaccine, a new composition, but it's not possible just by mixing the two basically. So that is what I mean by inventive step and non-obviousness. One of the most critical aspect, because frankly speaking, it varies a lot. So you may think that your invention is not obvious. I may think that it is obvious. If it goes to court, then the lower court may think that it is obvious. Higher court may think it is not obvious, and Supreme Court may think that it is again obvious. So complete interpretation based actually, subjective actually. Then it needs to have a eligible subject matter. You should not be just talking about things that do not exist. So, for example, if you want to file a patent on time machine, you are most welcome to do so, but you need to give a sound foundation based on which you are talking about that invention. Just talking that I have developed a flying machine which can take you back 20 years or which can take you forward by 20 years, then you cannot, frankly speaking, patent that, because you have not covered something that is making scientific sense, actually speaking. Eligibility subject matter also includes certain things like atomic energy based patents are usually in India, they are restricted, so government will intervene and they will, if they allow only then they would be allowed. So and you have to make a full disclosure, because as we talked about, it's a quid pro quo, so you need to make a full disclosure. Basically, the idea of this disclosure is that once your patent expires, say after 20 years, then others, based on that understanding or the teachings that you have disclosed in that invention, others should be able to exploit that invention on their own without coming back to you and looking for more information. So that is why full disclosure from a patent point of view becomes important. I can take some more questions right now, because after this I will just touch a little bit about the some business and strategy frameworks. I'll quickly run through them. So before that, if there's any question on patent, I'll come back to patent again a little bit. I want to talk about the specific strategic aspects on patent. But before that, any questions I can take.
Yeah, Diptano had one.
Yes,
Yeah.
sir. So my question was, sir, is the concept of an assembly line, is it considered a intellectual property or can it be patented? Because, sir, it is largely a managerial decision.
Yes. So if we talk about what can be patented, okay, just keep this in mind, because I'm trying to put this in a very simplistic manner. what you can patent is generally things that are technical in nature. So you have to show some kind of technical advancement, or whatever innovation that you have done should be of technical nature, not this administrative nature. So from your example only, if I just draw another example, let's suppose a simple exercise has to be performed, that is for example, door has to be opened. Okay, your problem is that this particular door is there. Now, some way we have to open this door. So now you can come out with two kinds of solution. At least I can think of two kinds of solution. Number one, you can put a doorman. Okay, so that doorman will open the door and close the door whenever somebody is supposed to enter or exit. Now, there is no technical input here. This is basically an administrative solution. So for those kind of things, you do not get a patent. Okay, but instead of a doorman, if you use some kind of sensor on top and then a sliding mechanism by which the door opens, so that, because you have put in some technical improvement on that, those things then become eligible for production under patent. So just think about the old days when Edison invented, tungsten based bulb and all. So anything like that, whatever you typically deal with, because you are all engineering students, right? So those things, whatever you are dealing in day to day life, which involves some kind of technical thing, so definitely those things can be protected. Anything that are purely administrative or that are purely human activities, generally speaking, those things cannot be patented. So to give you another example, you gave an example of assembly line, but a lot of people, they come out with platforms or apps these days. Okay, say for example, this aggregator apps and all. So generally, they do not take a protection on, for example, Uber or Ola for that matter. They do not have a patent on just aggregating, taxi rides and all. They have patent, I believe they file patents, but they file on certain specific aspects. Say, for example, how they are processing the information, or the distance wise and all these kind of things. So they take a patent on those particular aspects, but not a mere activity where they're aggregating. So long time back, at least in US, 5-10 years back, people, they tried to file a patent which was essentially a banking activity. All they did was convert that into a digital form, into a software which you can use in internet or laptop and all. A court interpreted that and found that what they have done is basically facilitating a lender and a borrower, which anyways the banks are doing for, I think, thousands of years. So they were not doing anything new, that way speaking. It was a known human activity which they just converted from normal form to a digital form. So again, those kind of things are not typically protected under patent. In an assembly line, though, obviously the start to end thing may not be protected, but within that assembly line, if certain function is being performed, say a robotic arm is using certain tools, or the way the robotic arm is recognizing something, optical recognition or whatever it may be, those minor part, the subunit of that innovation, of that technology, can be protected under patent. So always do not try to think about the larger picture, because usually the larger things are not protected under patent. But even you say, for example, if you work for a company or you start your own product line or venture and all, you may not be thinking about developing your own assembly line or something. You may think about a way by which you can enhance a particular assembly line by either, say for example, the way you screen your products at the initial stage, or the way you detect or ensure that quality is maintained. So there are a lot of technologies these days, light based or weight based, whatever it may be. So you can maybe innovate on those particular lines and come out with things which could be patented. But yes, if you're trying to think about patenting a complete assembly line start to end, then generally speaking, there could not be any novelty in that particular thing.
Sir,
Yeah, please.
sir, what if we violate laws related to copyright and trademarks, but we are unaware of it?
Unaware of what? Copyright, trademark?
What if we violate laws related to copyright and trademarks, and of which we are unaware?
You want me to touch upon copyright and trademark a little bit?
Yes, sir.
Okay,
Sir,
so
his question is, suppose a person doesn't know that this particular thing has been copyrighted or trademarked. This is a particular, he makes a design of particular thing and he doesn't know that it has been already trademarked. So will that person be charged or something like that? Am I right, Pranjit?
Yes, Bhaiya.
tell me something. Suddenly you come to driving road, and then you suddenly cross red light, and then if somebody gets hold of you and says that why did you jump the red light, and you tell them that I did not know that we need to stop and red light, do you think anybody would listen? So the same applies here, because a very basic fundamental of law is that ignorance of law is no excuse. So this applies for all branches of law, whether you're talking about criminal law, civil law, or whether you're talking about Indian law or US law, UK law, whatever it may be. So just because you do not know, you cannot claim that I do not know this particular law. You have to know, and court or law basically assumes that you are aware about it. So, say for example, you become a tax-paying citizen, you become eligible to pay tax because your income reaches a level where it becomes taxable. But then you don't pay. So then you cannot take the excuse that I did not know that we were supposed to pay tax on this particular. Idea is you, if you're starting a business or anybody else, you need to figure out what are the laws that would be applicable to you, and you need to carve your way through that. If you need to set up a company, you need to set up a company. If you need to follow the compliances that are required for a company, you need to follow those compliances. And forget about patent. That's obviously something that is luxury in a way. You take it only once you feel that you need to take it. But there are a lot of other laws that become applicable to you irrespective of whether you want them to or not. For example, tax laws definitely become applicable, whether you look at income tax, which is a direct tax, or GST or other kind of laws, which are indirect taxes. You cannot just shy away from those things. So you need to be aware of those laws. That's something that is your burden, or for that matter, everybody's burden. That's the way it is for everybody.
And I also get something reminded of like something similar happened with Helen Keller as well.
Mhm.
She wrote something and that was already published somewhere, but she told him before law that she didn't knew, but legal actions were taken against him. Yeah. So,
Okay, okay. Yeah, so this is the case with law, basically speaking. It has nothing to do with, say, intellectual property or copyright or trademark. Because see, a lot of cases has happened where people filed innocuously a trademark application. They did not know that somebody else has already filed a trademark application. But then, point is, you cannot take the defense that I did not know. Either you, drop your claim, drop your application, or you stop using that. But that's the only way. You cannot take, at least that defense is not allowed in any case. Even if you commit a murder and you take the defense that I did not know that by doing this, so that is not allowed. So basically, that is what it is. Should I quickly touch upon a little bit about strategy and business framework that I just thought to include for your particular session? If you are starting a business, what are the things that you can think of?
so if you want to quickly touch upon them, we have since the session is being liked by a lot of students. So
Yeah, so I'll just touch for 5 minutes because I've done an MBA, so I just wanted to share with you whatever I have learned so far, basically from my
yeah, you can
MBA.
take more than that, sir. You can take more than that. It's not.
Let's see. Okay, let's see. It kind of depends whether you have any questions or not. But I hope at least in this particular segment, you should not be having too many questions, because this is not an area I deal with day in and day out. But then that way speaking, nobody does also that way. But anyways, let's touch upon it, because at least point is it should come in handy in some point for you guys. Uh, Actually, if you look at it, you should not follow any particular business strategy or framework just because it is there. You first need to say what all would suit you, or whether that particular requirement would be aligned with your particular requirement. Now, even if you're thinking of starting a business, broadly speaking, there will be two ways to approach. Either you know what you need to do, because let's suppose by working in a particular field, you have developed some kind of technology or solution that you know that you need to work on this particular area. For example, when the Bansals and all started Flipkart, that's the only business they knew, because they also worked in Amazon and they felt that we are comfortable doing this. So let us launch a online portal and all. So that's why they worked on that particular line. It's not that they thought about, okay, let's study the whole market, the whole Indian scenario, and then set up a business. Generally, this is the other route, but generally these things are taken by large corporates, or when somebody is planning a lot. So, for example, when Reliance thought of branching out to telecom business and all, they obviously would have done a lot of study to understand what the market is, and what the potential of the market is. And based on that, over the course of 3, 4, 5 years, they came up with this geo platform and all. So the point is horses for courses basically. So there's no particular framework or business strategy that can guide you through the complete process. Uh, they can show you some way by which you can maybe think basically. And two ways by which you need to keep in mind think basically are one, focus on the external environment and the internal environment or internal capabilities. So this does not only apply for businesses in general, but for any particular other area also. Even if you look at yourself from a career point of view, or just yourself, basically you need to factor in two things: external, what is existing outside you, and internal, what are your capabilities, whether you're good in this particular subject or whether you're good in communication and all. So all these things combined only help you to chart out your strategy and the plan that you need to take. I, in general, have covered four aspects: external environment, couple of tools that you can use; internal, and then certain couple of tools that you can use while you are dealing with an organization or policies, and couple of things which are specific to technology. So for the external environment tools that are used, I'll just mention them little bit, touch upon them. You can Google them and find about them later also. This PEST tool, PEST, and sometimes also combined with EL, is a pretty common tool. Political, economical, social, technological, and then environmental and legal. So this is what PESTL means. So basically, if you're trying to look at an external environment, you try to look at these four aspects or the six aspect, and you see where you stand with respect to this. So if suppose Geo is launching telecom, so they need to see what kind of political environment is existing in India or outside India. So all these kind of things can come into the picture. Quarter 5 forces is one of the very established framework, basically business framework for understanding the external environment. So here you identify who are the players in the market, what kind of competition exists, what kind of products you have. So all these things combined is then analyzed basically. 3C is a pretty common, straightforward one where you just analyze your customer, the company, and your competitors. So basically, it combines in a way the external part and your company. So if you look at the PESTEL, this is what it is: political, economic, social, technological, environmental, legal. If you talk from patent point of view, technological becomes a little bit more important because these days technology changes very fast, at least in the high tech sector and all. So a lot of strategies based on this particular aspect are also used. So leapfrogging. Say for example, take a simple example of QWERTY keyboard. Now a lot of companies, they came out with keyboards which were not QWERTY based, ABC based or some different form, but none of them worked. They simply did not work because people have got so used to QWERTY that they cannot change from this QWERTY. The only way to change from QWERTY would be when we leapfrog from the keyboard system entirely and we use maybe voice or some other gesture based input system. So that is why keeping an eye out on these particular aspects become a little bit more important for anybody, whether you are a student or whether you are just starting out or whether you are an established player. You need to keep these things in mind. From an internal point of view, generally you try to see what kind of value chain you are building into out, and how in what way you are adding value. Everybody is adding a value. Whether you look at Flipkart, obviously they are adding a value. They are replacing couple of things with something else. So that is the way it is. Value migration is the way things change from one particular industry to another industry. So these days, what people are saying is that value is in a way migrating from public sector banks, government banks to private sector banks. So these are things that you need to keep a lookout for. A lot of different ways, value actually migrates from one particular sector or industry to another sector. Netflix is also a case of value migration only. Earlier, people used to go and watch movies, but nowadays, in a way, people are shifting to Netflix. So in a way, the value of entertainment and all that is migrating. Resource-based view is a very good management tool. It was developed by J. Barney. You can read about it. Basically, you need to see what kind of competence you have with your product, and then you develop your competitive advantage based on all the things. So this is the framework that is built on resource-based framework. So first you need to see whether you have a valuable resource or not. then you need to say whether that resource is rare or not. And in a way, if you see, patent allows you to get that kind of rare or an immutable resource basically, because obviously if you have a patent, then nobody else can copy it. So once you have these three, then you have something called as competitive advantage, because then it cannot be replaced easily and somebody else cannot start using it. So it need not be always technology based. Sometimes the way companies organized is also valuable or something that cannot be easily replicated. So that is what it is. Organization policy. So basically, what I try to cover is that if you look at marketing aspect, then there are a lot of frameworks dealing with marketing. There are a lot of frameworks dealing with operations. In marketing, the common frameworks would be four P's, which is product, place, price, promotion. You need to factor in these four aspects at least if you're trying to market something. What would be your product or your service? Where you want to market it, the place, promotion, how you want to promote it, digital, this way, that way, and obviously the pricing part. And along with that, this is STP, segmentation, target, and positioning. From operations point of view, a typical framework that can be used is asking this question, five whys and then five hows. So why basically allows you to drill deeper, find out the root cause of the problem, and how basically allows you to come out with a solution. So this is something that at least in operations people use it pretty common actually. Some other operational tools or frameworks would be lean management, just in time management, Six Sigma. I think you must have heard about Six Sigma. In marketing, you search on these words, Ansoff matrix, Boston Consulting Group matrix. So these are different frameworks by which you can identify what kind of product or mix or what kind of market you need to enter and how you what are the capabilities based on which you can enter. From an IP perspective, I just covered an organization where at a very basic level, you are just a defensive company where you are just filing patent for the sake of filing patent. But gradually, some company mature and become visionary where they file patent with a complete purpose in mind, not only to make profit out of it, but to control all the thing. So companies like IBM and all, they come into this particular category. They have a complete different way of managing and looking at intellectual property. Technology point of view, if I say, there would be a couple of things that you can. I think you would be aware of this thing: product life cycle, experience curve. You might be aware of this. Innovation diffusion is something that is new and very interesting. Uh, this life growth and all, I'm not covering. I think you are familiar with the technology curve and all, how current technology is, changed. This is something that you can study a bit if you want in your free time and all. There was a book also written on this, Crossing the Chasm, CHASM. Basically, it says this that every technology has a particular curve. So there would be some few early adopters, innovators and early adopters. So they would be far and few, but they are the ones who would use the technology irrespective of what are the benefits and all that thing. Say, for example, this smart watches and all, when it started out, there would be a couple of group of people, say, for example, nerds or whoever, they would start using it for the sake of using it. But the majority, the benefit lies in crossing this gap and reaching this particular segment, the pragmatist, because these are the mass users of that particular technology. And what this author tries to say is that there is a gap, there is a chasm in crossing this early adopter to this pragmatic level, and you need to find out ways to cross this gap. And the book talks about all that particular aspect. So in your free time, you should read that book. It's a very good subject on this particular aspect. Other frameworks that you can read about would be something that combines all these aspects: external environment, internal capabilities, and all. So one common one is what: strength, weakness, opportunities, threat. Strength and weakness are your internal, and opportunity and threat are your external part. McKinsey 7S framework. Blue Ocean strategy is also something that is new, that has come up. You can read about that. There is a book also on that. Basically, it says that you need to, capture a market or a value which is new or nobody is competing on that. I mean, red ocean or something in compared. VMOST is just a way to look at things. It stands for vision, objective, strategy, and tactics. So, if you're starting your way and you're trying to chart out a course, so then you need to have these kind of things in mind, that we need to set up a vision for our company, a mission for our company, objectives, what we want to achieve, strategies, how we want to achieve, and all that, and then small tactics. For example, Flipkart, if they come out with a Diwali scheme or something, those are tactics, but they have a strategy in place which they run for 3 to 4 years, how they want to play out, those kind of things. Business model canvas is something that I'm not very familiar with because this is something that was not covered in our MBA time also. But what I looked at it, what it tries to say is that just like any other business, say even if you don't look at this model and if you don't know about this canvas, even if you're just starting a small stall of vegetable selling or something, then you need to know about a couple of things. For example, you need to know how your money is coming in and how your money is going out. So this canvas is talking about that, and then how you are managing yourself internally and how you are managing again managing yourself externally with your customers and all. So that is what this model is talking about, essentially speaking, managing your money and managing your business from internal and external point of view. So this is what I have on general strategy and business. Any questions on that? Okay, so let me quickly tell you about certain aspects of technology that we work on from a research point of view. So, hello.
Sir, can you recommend some books?
So actually, I'll recommend books that are dealing with say personality development or management. Talking about certain management aspect and all. Having studied all this, I believe a book that you should read would be some, because we are not familiar with the way we should be making decision. So there's a book called Decision Book. I'm forgetting the name. Maybe you can just Google it. You'll find the book. I read it over Kindle basically. It's a very short book in a way. They talk about 50 decision biases that we typically make, and I think you will find it pretty insightful. Certain common things by which we can err while making our decision. It's a
Sir, which
fantastic book.
book? Sir,
Name
which
of the
book?
book is Decision Book.
Decision book.
Yeah. Okay.
Author name, sir? Any, when we
I
will
think
see
you
on the
can just
Google.
Google search the decision book and you'll find it. I'm not
Okay.
recalling the name of the author, but basically, I think in the cover page also it should say that it talks about 50 or 51 decision errors or biases that generally we have. I think it's a good thing to learn actually when you're starting out, whether you start your own venture or you work for a company or whatever. As a human being, also you should be knowing because it talks about very simple thing which
Sir,
we find.
one second, please. Decision book for whom, sir? There is a we search on the Google. There is a name called Decision for 50 models or something like
That
that.
one.
Decision book for 50 models, right?
Yeah, can you
The black cover is that the international bestseller, new
can you
and
read out the
updated
name of
edition.
the author, please, so that everybody
Okay, one
can.
second, please. Yeah, one second, please. I'm just checking. Okay. Author name, I think Roman, something like that. Mikal. I just said a screenshot. Okay, so one second, please. Something like I am writing in the chat box. Okay.
Okay.
Okay, sir. Yeah.
The point is just search on decision book and try to find out the word or phrase 51 models, and I think you will get it. It's a short book. You can read one chapter and complete it within 5 to 10 minutes. I think I found it to be a book where you can take notes also. So try to read that book. Another book from personal finance point of view, which would be good for you, would be Rich Dad Poor Dad. Try to read that book. And this book, Crossing the Chasm, uh, I would suggest from a technology point of view, you should definitely read this book.
Yes, sir. Smita, I think she said in the chat box that book.
Yeah.
Sir,
Please.
yes, sir. Actually, we have experience of in actual field and where are we right now? So, sir, can you tell me how the books actually help and how to analyze them? Because it is totally different when people are in actual field of business or doing something.
See, I can only tell you what I feel, and what I feel is that see, none of the books can help you significantly. Even say, for example, if I have done the MBA, I can say at the same breath that maybe it did not help so much, but then at the same breath I can say that it helped also. How they help is that see, in a way we all as humans know most of the things. So the way they help, as for me, is that they bring the things from the back of our mind to the front of our mind. Say for example these tools, I can tell you you would not be using these tools at all, but yes, let's suppose if you reach that stage where you need to use, then at least you know that there is a tool called SWOT, or there is a McKinsey framework I can look up, because these things are available in the net. The point is, at least from the back of the mind, they should come to the front of our mind and let them remain there. Maybe you're not using it, but the purpose of the book or any education that you take is that it should just keep it at some comfortable place at the mind. Another way is that if it is not in your mind, then at least let it be there at the back of your mind. So that is how I feel that books or anything helps you. They will not make any significant or milestone changing. They will not bring about that level of change for you. But yes, they should be there from your mindset point of view. They should be there, like a toolkit or chain or Swiss key. At least they should be there from your mind.
Yes, sir, I got it. Thank you.
Hello,
Sir, can I
sir.
ask one question, sir?
Yeah, please.
Sir, think of an example that we have a customer base, and the customer is also ready to take a particular product, but the product is similar to several other products. Like you can say a tech startup. There are so many tech startup, and the idea of a tech startup is it's open. Can we, if we launch any tech startup, then can any one person means, do a strike on the idea, because idea is something no one owns. So this thing, can anyone do a copyright strike or any claim on a particular idea?
No. So idea is not at all protected under any realm. In any intellectual property, you need to cross a barrier, which is called an idea invention barrier or idea innovation barrier. Say, for example, you thought about a story, Romeo Juliet kind of whatever it may be. The point is, if it is there just in your mind as an idea, then you are not getting any kind of protection. You need to write that down in a book or somewhere, so that it is there for anyone else to observe that it is there. Generally speaking, you need to publish it also. Then only you reach the state that where you can say that I have a protection on this. Otherwise, just mere idea floating around in your mind is not at all granted protection under any law, in any country.
Okay, sir. Thank you, sir.
By the way, if I can just give you one more example, you know who invented this telephone, right?
Graham.
Yeah, Alexander Graham Bell. And no, I'm not asking this, but I think you know that he invented this almost 150 years back. Okay. Now, even at that particular time, I would say it was around 1860s or 70s, I believe. When he filed the patent, whatever 1870, say for example, when he filed the patent, the same day another guy filed a patent. Okay. So just keep in mind that if you think that your invention is new and then nobody is working on it, then don't remain in that illusion. People are working on that technology. During Alexander Graham's Bell time also, there was intense competition, that was speaking, that somebody else filed a patent on the same day. You can search on Google. The guy's name was Elisha Gray, and later on, court realized, and court, it went to court, and court granted this in favor of Alexander Graham Bell, because it came to light that the other guy actually stole certain research material and all to file that patent. But the point is that be wary. If you have an idea and if you think you can replicate that and convert that into some kind of material form, copyright, software, write that down, or patent, file the patent. To do that, just don't keep it hanging in your mind, because then you're not getting any kind of protection.
Okay, sir. Thank you, sir.
Hello, sir.
Hi.
Sir, how can academic institutions like NIT Agartala benefit from patenting their research happening on campus?
So actually, these days, a lot of academic institutions are filing patent, but they are filing for different reasons altogether. Also, at least a lot of private universities and academics, they are filing patents because they just want to market and show that we are top patent filer, or we are filing 100 patents per year or something like that. But the point is, just like anything else, ultimately a patent is a property, and you need to think in terms of a property only. If you want to file a patent, then obviously you. So, have you read this book, Seven Habits? Uh, so maybe you can read that book also. So one of the habits that they talk about is start with the end in mind. I think that's where they talk about this. But the point is, try to imbibe this philosophy at least. Start with the end in mind. So even if you're thinking about innovating, just think about 5 to 10 years down the line what you want to do with that innovation. For example, NIT Agartala also, if they want to file a patent, then just for the sake of filing a patent that your name will appear or it would be there in the research paper and all, that's definitely one objective. If you want that objective, then definitely you can file a patent and you can file hundreds of patents like other people are doing. But the other objective, if you're looking at some kind of commercial viability, or even if you're not looking at commercial viability, if you're looking at some kind of social acceptance of that particular technology, then keep that in mind and then do your work. In that case, also you can file the patent and then make it open for others to use. In the sense that you do not claim your patent. For example, Toyota did a lot of their work that way only. The scanner that we use, I think QR code or some other kind of technologies these days, I think a couple of them were developed by Toyota only, and they made it open for others to use. So at least you can choose then what you want to do. For NIT Agartala or for anybody else also, I will suggest that keep that in mind, how you want to exploit and how do you want to use your technology, and file your patent. Even not filing patent is also an option, and that's also part of a strategy also. But then think and then do. Basically, there should be an alignment between your uh, thinking and then aligning it with your IP or patent filing objective, basically.
Sir, can you please give more examples like regarding patent?
Yeah. If you're just asking about patent, then let me quickly go back to the slide. By the way, is time an issue for you guys?
No.
No, sir,
You
not yet.
continue.
Because I can take 10 for 15 minutes more. I have no problem.
No, sir, it's depend. If we are interested, then you can take, sir.
No. The point is we should not get bored or something.
No, sir.
Okay, so I'm just sharing my screen again just for one particular slide I'll show you. Just give me 2 seconds. So these are the 3 slides I will cover quickly. Generally speaking, what can you patent? In general, any method. So a method by which you are creating sodium chloride or purifying sodium chloride, or a process by which you are preparing a solution. So those kind of things, a system, a device, a machine, composition matter, pharmaceutical composition, new useful matter, say for example, plastic or a polymer. So anything like that, this can be protected. So generally, I touched on this from the perspective that anything that involves some kind of technological input. So anything like that can be patented. Now, on the other hand, you should also know that what cannot be protected. So, mere discovery. If you discover a new bacteria, okay, generally, even if that bacteria has a lot of functional property that you can isolate or you can use for creating an enzyme and all, generally speaking, that bacteria is not protected under patent of any form. Or if you discover a law of physics or of any kind of scientific thing, say for example, you discover a new way by which actual time travel can happen. So you will not be able to patent that particular discovery or that particular law of physics or something like that. But yes, based on that, if you apply that and make an application out of that, based on that laws of physics and all, if you create some kind of device and all, then it becomes a machine or a system, and then you can protect that. Then I touched upon this also, mere admixture or combination. So if you're just combining 2, 3 things, 1 or 2 things, and nothing significant or advancement is happening on that, so that you cannot protect. Method of agriculture, so how to plow land or how to cultivate, so those kind of things, or a general surgery, those kind of procedures are not covered. Whole plants, these things are not covered because plants are covered separately under plant protection. We talked about that. Traditional knowledge is not covered because there is nothing new that you have done on that. It's already known. So if you mix honey and maybe ginger or something and create a syrup, people know it for thousands of years. So you have not done something new on
Yes,
that.
sir.
And from software point of view, these are the things that you should keep in mind, that pure mathematical formula, okay, any kind of mathematical formula, that these things are not protected. Any algorithm pure is not protected. Computer programs are not protected because those then come under copyright. A business method, we talked about this loaning system. If you just digitize, those things are not protected. Or scheme of accounting, mental act, these things are not protected. Now, there are some very simple examples which have secured patent protection. So these can include a concrete mixture, pen, artificial kidney, even French fries. So if you devise a new way by which you are creating French fries, you know, combination of temperature, oil, and all, so you can maybe patent that also. Cleaning surface, barcode, 3D touch of mobile phone. So barcode was patented, I think, way back in 1950s and 60s. And just to motivate you, school students are filing patents these days also. So one patent was filed, this particular number, they filed, and this particular guy, he filed for recycling soap water. So these are the things. Any further question on this?
Yes, sir, now got it. Thank you, sir.
Sir, I have a question.
Yeah.
Sir, say for any startup, like somebody who is just starting up, like if it is a manufacturing-based startup, which is basically copying some idea from a company which is operating somewhere else in the world, and we are just like say, manufacturing something and selling it to people. So, is there anything other than trademark that needs to be registered under intellectual property?
Not necessarily, but again, as I mentioned, even before you start thinking, you need to do your research work. So let's suppose you say that that company is based out of US, you should do your study to find out whether they have secured any kind of production in India or not before you start manufacturing that. If they have, then perhaps the best way to go about it would be to either take a permission from them by way of a license, or otherwise you devise a way by which you're not hitting directly them, so circumvent all that thing. uh,
Means,
Clearly
sir,
stating,
directly we cannot copy from them, right?
no,
Same thing.
directly you cannot if they have a production in India. So that is why you first study, and only after study you do your planning. So if suppose now there could be two situations. They can either have a production in India or they cannot. Okay. If they have a production, then your job is done. You take a permission and that's it. If they don't have a production, then also your job is done. You then do a solid research and find out that they are actually not there. Okay. Because sometimes what happens that company, they don't file it in their name, they could be filing it as a subsidiary or through some other company. Okay. Because say for example Microsoft, the patents are not owned by Microsoft, but a company called Microsoft Licensing. Okay. Now the name makes it clear that it's owned by Microsoft, but the point is, if you're just searching for the name Microsoft Corporation, then it's not owned by Microsoft Corporation. It's owned by Microsoft Licensing LLC. So do you study that way, and if you feel that that particular company has not secured protection in this, then you can at least start manufacturing. So for these kind of things also, we all do studies. We generally call them, freedom to operate searches or non-infringement studies, to find out whether whatever you are doing or whatever work you want to do, whether they can be done freely in India or not. Freedom to operate or validity searches.
Okay, sir. And sir, I have one more question. Sir, can business strategies be registered as trade secrets?
So trade secret, as the name suggests, is secret. You do not register it because ultimately, if you're trying to register, you are disclosing that particular information. Even if you are filing a copyright, you need to disclose that this is my poem, and I need a copyright of this. Software, you need to show the codes. Patent, you need to disclose the technology. So trade secret, basically, the point is you keep it under lock and key. That's it. If you want to find out, just do a Google search on Coca-Cola and trade secret, and you will find there are a lot of stories also going around that only two people have the key to that particular locker or safe where they keep that formulation hidden. So they go there maybe once a week or twice a week. They manufacture that particular concentrate of that particular syrup, and then they distribute it for other plants to dilute and use or something like that. Even KFC has some kind of trade secret in their formulation, the recipes and all. So trade secret is secret. You keep it secret, no registration, nothing. Nobody should come to know except for those who need to know.
Okay, sir. Thank you, sir.
Okay, so anything else?
Yeah, if anyone has some question, okay, then
I guess not. So,
so I before concluding, I would like to take one last question. Uh, yeah. So, sir, there are a lot of grassroots innovators in India. Like there are a lot of people in my village also. They build some jugaad kind of innovation, and they used to plow their fields or their certain kind of new variety of plants they have produced. So, but they don't have the enough expertise to patent that thing and turn that into a potential business model or framework. There are a lot of NGOs that are working in that field. That one of them is Honeybee Network, that is being done by one of the professor from IIM Ahmedabad. What they do is they take up their idea and they patent it, and while giving it to a certain company, they pay them some like 20 lakh or 25 lakh, depending upon the uh, feasibility aspects. So, is there any way to help those grassroots innovators who they who don't have basic education, but they are very rich through their mind. They have developed something new and they are innovating.
Yeah, actually, a very good point, Raj. And actually, this is the exact reason why I'm doing this session with you guys. Because I look at it from a little bit different perspective. Say we call ourselves a developing country or underdeveloped country. US or the Western European countries, they are developed countries. I feel the reason they are developed countries and we are developing simply because we have not exploited our mind to our potential. It's not that we were not innovating earlier and suddenly we have started to innovate, but the point is we never thought about how to exploit that particular innovation in a way by which we can make some money out of it. 150, 200 years back, guys like Bell, Alexander Graham Bell, Edison, they completely played on the patent game only, and that is why they became what they became. Uh, Edison ultimately, the company became GE, the company that we know these days, GE. But the point is, see, in India also patent law existed from middle of 1850s. When British came, they established this patent law. I think the first patent act, whatever name it may be, was enacted around 1856 or 1850. But the point is, nobody was aware of that. But on the other hand, US, whoever was innovating, they knew that if I patent it, then I can use it, and only I would be able to use it. So people like Levi's, the jeans company, all these companies, they came about in US, and that the reason why US became a developed company simply because they created a culture where the law, the system, everything else allowed innovating and to percolate the whole information. Here things are changing, and that is where we also play a part. That is why we do this session, so that we can create this awareness. For example, you as students, because you are from technical field, you know about patent, but maybe not about other intellectual properties. So that is why at least maybe little bit information about geographical indication, designs, integrated circuit layout. These things would be helpful for you, and that is why you do this awareness session, so that ultimately maybe couple of you may go down and talk to those village people or whoever it may be who do not have that awareness. Ultimately, then only as a nation the awareness level will increase, and then we can see more filings and maybe more exploitation of that innovation, which is not happening simply because that information, the awareness has not percolated down. And as a society, I want this to go down to the extent possible. In fact, frankly speaking, 15, 20 years back, other than some top companies, pharma companies, or couple of high-tech companies like Samsung and LG, no one were filing patents also. Most companies have started filing patents only now. There are a lot of companies who don't even file patents now, even though they are doing innovation. A lot of IT companies are not filing patent, even though somewhere there they could be innovating. But then on the other hand, there are certain institutions or certain companies who are just filing patent for the sake of filing patent because they don't even know what to do with that, but they just want to file. So both ways happening. But yes, the idea is as a society we need to catch up and get this awareness going.
Yeah, basically that awareness part is the key.
Yeah. Because this is not the first time I'm hearing. I know a lot of farmers, they innovate some way or the other. They create a pump to or do something electrical, some kind of circuitry they do. but the point is nobody is there to tell them that you can maybe patent it or you can do some protection. You can take some kind of protection on that.
Rashmita, there's one question in the chat box if you can read that.
Yeah, yeah.
Yes. We have a question from Deepshika. If in an enterprise an employee has invented a new product, then in that case who will own the right, the enterprise or the employee?
So what happens is always the company owns, but let me explain you how it happens. An employee, once they enter, they sign an employment agreement. In that employment agreement, along with certain rules, conditions, and all, it also says that whatever work you do, it would be done on behalf of the company. So let's suppose if you join as a software engineer also, or if you join as some kind of other person also, you're doing the work on behalf of the company as an agent of the company, and that is where from this employment agreement also, basically what happens is you assign or you give away your rights to the company. So the owner of that intellectual property or anything that you do rest with the company. But mind you, the inventor is always the person. So if you, as an employee of a company, invent something, your name would always be there as an inventor because something is invented by an intellectual person with a mind only, right? Also, although these days debate is going on whether AI can be, made a inventor, but then that's a different aspect altogether. But the point, plain speaking, is that generally employees can be inventors. Their name would always appear as an inventor. But by way of this employment agreement or the contract, they assign their ownership on that intellectual property or patent to that company, and the company becomes the owner. So Microsoft and Samsung, they own this technology or these patents because it's assigned by their R&D people or their employees. Because the company itself doesn't have any mind; it cannot create any intellectual property on its own. So that's how it works.
Sir, one more question. Sir,
Yeah, please.
just last question. So suppose that we know about the PNP, paper and parcel company, the boy he started the company. So suppose that sir that idea ki like in a circle like in a 2 kilometer 3 kilometer one person will work in a next 2 3 kilometer there another person will work and they design algorithm like that, okay, and suppose that sir this idea Amazon use this idea, suppose that in a upcoming day, suppose that in 2 years Amazon use this idea, okay, we use this idea we will get good profit, and suppose that guy know ki oh he's copied my idea Amazon's that job wager he copied my idea, then what will happen, sir? He will claim ki he copied my complete whole idea. Whatever I'm using
See,
the algorithm,
if
he
I
not
look
able.
at this only from the perspective of copying an idea, or at least let's not call it an idea because he was implementing, so there was something definite about that. So if he's copying that, then maybe he can sue. He can go to court and get a redressal. That is definitely there because obviously you can go and take recourse of the court of law. Nobody is stopping you from doing that. But to just answer that question from another perspective, usually these kind of things again may not be patentable because most of the things are administrative by nature. So
Okay, okay, okay,
2 kilometer, 2 kilometers is maybe that is not something new, and maybe anybody else can also replicate without even talking about copying because he has not copied something that is protected. He has just merely replicated that. Okay, but
okay,
from a
okay,
patent perspective view, now here is what you can do to build strategies: is you identify by what means you are creating that 2 kilometer radius, how you are assigning that, how you are creating that map and the grid and all that. Okay, there would be
okay,
a unique mechanism which may be employed by you. And if there's some technical features, say for example GPS based or this and that way, whatever it may be, okay. And then how you are processing the request and how you are identifying queuing the data and everything. So those kind of things within that entire idea that you're talking about, within the whole business innovation, these minor things, subunits of innovation, these things may be protected under patent. At
okay,
least
okay,
they
sir, got
stand a better
it.
chance actually.
Okay, sir, got it. Thank you.
Yeah.
Okay, I guess that's it. So, thank you very much, sir, for accepting to be here, and I hope all the participants took something of value from this session. And we really, really thank you for taking this session. It was really informative, and it was really enjoyable.
Yeah, thank you. Same here.
Yeah, thank you, sir.
Okay, thank you.
Yeah, actually, the session was really very informative, sir, I guess, and a lot of us have got a very good insights about that. And a lot of people here are also developing some startups on their own. So definitely they will take something back from this seminar, and if they are developing some products that are helpful for their startup also, then they will definitely look
Yeah,
after
so
that.
if any of you have any further queries at any point of time, reach out to me over LinkedIn, or you can take my contact details from the coordinators, and reach out to me. It should not be a problem. As I mentioned, the point is to create this awareness and bring about innovation within India. Obviously, that is happening, but let us speed that up, and then I think sooner we can become a developed nation. So
Definitely. Yeah, and guys, anyone, if you want to contact sir, you can just text the coordinators, Rashmita, Karthi, or me, and we will help you connect with him. And remember to ask any questions if you have. He's a very cool person. He will take time to ask, give his time to answer your queries and put things in perspective.
And if after this also you missed any question, or if you have any follow-up questions, maybe you can compile them, and then the coordinator can send them across to me. I'll try to give 2-3 liner answers if possible.
Sure, sure, we
Okay,
can
sir.
do
Sure,
that.
sure. Thank you.
Okay.
But the point is, this is not a one-time approach. Let's keep it long time. So at any point of time, you have any question, anything that is coming to your mind, feel free to reach out at any point.
Yeah, sure, sir.
Sure, sir.
Yes, sir. Thank you, sir.
LinkedIn account has been given in the chat box. You all can check it out from there.
So all right then.
Yes, I
It was
guess.
a pleasure. Thank you.
Thank you, sir.
Thanks a lot.
Thank you all.